Okay, so it's very good afternoon to all the participants in this online session. As you all know, that our college Budge Institute of Technology is organizing an IP awareness program. The title is that Intellectual Property Rights and IP Management for the startup, and in collaboration with the NIPM. So NIPM is a National Center of Excellence for Training, Management, Research, Education in the field of intellectual property right. The main objective of this institute is to cater to the need of training of examiners of patent, design, trademark, and geographical indications, IP professionals, IP managers, imparting basic education to user communities, government functionalities, and stakeholders involved in creation, commercialization, and management of intellectual property right. Mr. Abhishek Sen is our today's speaker for this program. Mr. Sen is currently working as an examiner of patents and designs, the Patent Office Kolkata, Ministry of Commerce and Industry, Government of India. Mr. Sen is BTech in Mechanical Engineering, MTech in Thermal Engineering, and joined Patent Office as examiner of patents and designs in 2016. He is also working as ISA examiner and associate with NIPOM program as a NIPOM officer from December 2021. So welcome Mr. Sen in this program. Now I would like to request our Dean of Academics, Professor Dr. N. Jana sir, to say few words about today's program. Sir, are you there? Jana sir?
Thank you, Janto.
Yes, sir. You are audible.
Am I audible?
Yes, sir. Yes, sir.
Okay. Good afternoon, everyone. On behalf of Budge Institute of Technology, BBIT, I do welcome all the participants over here for this 1 hour online webinar on intellectual property rights, which are very much important, at least for the organization like us. BBIT since last 2 years, we have had progression on this particular aspect. Huge improvement is there as far as patent filing and then publications and other things. So at this juncture, this kind of session definitely would be helpful to the budding researcher, including faculty members and students. And there are lot many issues which are related to this particular issue, where our guest speaker, Mr. Abhishek Sen, who would be definitely enriching the faculty members and the student members, whoever is joined here, over here. I do welcome Mr. Abhishek Sen sir here to this particular session, and you were really providing us at least a beautiful time over here to enrich us. So and other faculty members, whoever has joined in this program, and this is the right time because there are faculty members who are working on patent filing and others, and there are some issues which are definitely there, which may not be known to the researcher as a technical person, but as a let us say as an expert of this particular issue, you will be guiding us, and our faculty members and others will be definitely benefiting for this particular issue. So I wish all the best for this particular program, and especially Ashok Kumar Soy and Jayanta Boshak, who is really working hard as a part of our IIC cell, and Jayanta Boshak is working as a convener, and a lot of programs which are being conducted by them. So this is one of them. At least I would say in 2022-23, we have had a lot many progress on this particular aspect as far as our institute is concerned. So thank you, Jayanta, as well as Ashok sir, for this particular taking initiative for this particular session. So I wish all the best and great future for this particular program. Thank you, sir. Thank you. Thank you, everyone.
Thank you, sir. Thank you, sir.
Thank you, Jana sir, for your motivational speech on this particular context. So I would now request to Mr. Sen to start your session, sir. Please, sir.
So, thank you, both of you, Mr. Jana sir and Professor Narendranath Jana sir. Mr. Jayanta sir and Professor Narendranath Jana sir, for your brief introduction about me and the patent office, and the brief introduction about the IPR. Uh, Now I am starting my session. Uh, Before starting my session, I want to convey you, I want to tell you about the history of this program. That is the NIPAM program, that is a National Intellectual Property Awareness Mission program. This program was launched by our Honorable Minister, Sir, that is Minister of Commerce and Industry, Government of India, and it was launched on the occasion of 75th anniversary of Indian Azadi Ka Amrit Mahotsav of Indian Independence Day. At that time, this program was launched. That is 2021 in the month of December. And our primary target was to teach the students and the faculty member of all over the India. And our primary target was to teach about 10 lakh students and faculty members throughout the India uh, within 15 August 2022. And that was well reached by us. And after that, we used to get lots of requests from the institutions and the other startups and the other small companies throughout the India, from the India, from all over the India, that please don't stop these programs, and please continue this program. And we learn a lot from this program. And the even many institutes says that the quantity of filing patent from them is increased a lot after this program. So I request everyone to mute yourself, and after the program, I will unmute all of you, and you will get a chance to question of your queries, and I will love to give the answer of them. So I request everyone to mute yourself. Uh, And after that, our CG sir, our CG sir decided to continue this program, and now it comes under the NIPAM 2.0. This program is called the NIPAM 2.0, and under this program, today I am delivering the lecture. My name is Abhishek Sen. I am working as an patent examiner of patent and design in Patent Office Kolkata. So today's session is on IPR, Intellectual Property Awareness Program. Uh, mm, uh, Before, we have two types of properties. Generally, we know that there are two types of properties. One are tangible property and one is intangible property. For tangible property, the example of the tangible property is gold, car, house, furniture. The tangible property is the property, physical property, which can be touched. And the intangible property are the creation of minds or creation of human intellect. The example of the intangible properties are the invention, literary work, artistic work, design, symbols, etc. So intellectual property are there are six types of intellectual property, that are patents, designs, trademarks, geographical indications, copyrights, semiconductor integration, circuit layout, design. These are the different type of intellectual property we have. One by one, we will learn one by one uh, in the coming slides. In this slide, we can see that the different IPs in a single product. You can see a laptop, that is Apple laptop, and Apple sign is there, and the LED display of this laptop is registered under the patent registration. Body of the laptop, it's registered under the design registration. and the Apple sign that is registered under the Trademark Act, and the user manual of this laptop is registered under the Copyright Act, and the layout of the IC of this laptop is registered under the SICLD Act. So you can see, for to do a business, you can take the help of different IPs, and to merchandise a product in the market, you can take the help of, obviously you can take the help of different IPs. Now in the next slide, we will see that how we are surrounded by various IP product in our daily life. You please see this video, and you will came to know that how we are surrounded by the various IP product. In this video, you will see that you have saw that how IP is a very important part of our daily life. Uh, Without a IP product, we cannot imagine our daily life. How intellectual property can be created by using our brain and our resources and our time. We can create the intellectual property. Here, resources means what? Resources means, suppose you are a college student or a college faculty member, and you have the lab in your colleges, and you use that lab, and your brain is implement. You have given your time in the lab, and by using your brain and the resources, you create a new product. You can create a new product. The importance and the significance of the IPR is to protect your product, and from exclude others from using it. And another importance and significance of IP product is the utilize it to commercialize it, and by using your product, you can earn money. Utilization and commercialization of your product, it can be used by your own. You can license it or assign it to others. You can franchise it, and you can merchandise it. For a common person, it is a matter of pride, and for a academician, suppose you are working as a lecturer in your college, by filing patent or by awarding patent, you can get your promotions, or you can climb up in your career. And for the businessman, it's a matter of commercialization. He or she can commercialize his product, and by filing IPR, your brand value can be increased, and by using commercializing and using your brand value, you can earn and invest money. Now we are moved to our first topic, that is patent. What is patent? Patent is granted by a sovereign or state to a person, giving exclusive right to stop others for making, using, excising, vending, and importing. An invention for limited period. You can say patent is granted for a period of 20 years from the date of filing. In exchange for disclosing it in a patent specification such that anyone having ever a skill in the art can reproduce the invention. You have to write the patent application in such a manner, or you have to write about your product, how your product can be created, or how your product is work, and how your method is working in such a manner, such that a layman can read it, and he or she can produce that product by reading your specifications. And it gives rights to exclude others from using your invention. Suppose you have filed a patent and you have been awarded it, and so the sole owner will be you, and the sole owner of the product will be you, and no one can use that product without your permission. uh, this rights gives this is the patent rights that gives you how the owner has qualified right to use the invention. Now you are the owner. You have to decide how to use that product or that invention. You can sell it to others. You can give a franchise to others, or you can suppose you can make an agreement to a company that if, you can produce my product, but you have to give the some share from your profit. Uh, there is various way to commercialize your patented product. Now, what is invention? As per section 21J, the invention means a new product or process involving an inventive step and capable of industrial application. Uh, Suppose you think yourself you are in 1980s. At that time there is no mobile phone in the market, and at that time suppose you make a mobile phone. So you invented a mobile phone. So at that time it can be say it's a new product. So that that product, that is the mobile phone, can be patented, and it has the novelty step because it's a new product in the market. And if you created the mobile phone, that you have been awarded by patent. So in this way, in 1980, suppose in 1980, your product, that is mobile, can be a new product under section 21J. And as per section 21J, inventive step means a features if means a feature of an invention that involves technical and advancement as compared to existing knowledge having economic significance or both, that makes the invention not obvious to others. Suppose you have made a mobile phone and you know that someone introduced a camera in the mobile phone. So mobile with a camera become a new invention. So under section 21JA, the mobile with camera can be patented. So in this way, the advancement of a existing product can be done, and you can apply for patent for that also. Uh, in 1956, George Alfred Depenning invented an efficient pankha pulling machine, and he had applied a patent in Kolkata Patent Office, and this is the Indian first patent. has been awarded to him. That's why this is a famous phenomena. And there are some scientists and their invention are there. Thomas Alva Edison, who invented phonograph. Alexander Graham Bell invented telephone. Wright brothers invented aeroplane. Louis Pasteur invented the rabies vaccine. Alexander Fleming invented penicillin. Now we will see a good example. All of you maybe know him or her. He is Michael Jackson, and he is famous for his moonwalk. Mm, a dance step, you can say a dance step. Uh, uh, by he invented a shoe, but with the help of that shoe, he can tilt himself about 45 degrees. A normal person can tilt himself about 20 degrees, but with that help of shoe, he can tilt himself about 45 degree. And by tilting up to 45 degree is the famous step of this moonwalk, of his dance, that is moonwalk. He itself invented this shoe, and he applied the patent for his invention in US Patent Office, and his patent number is US 5255452A. Simply, you go to the Google patent and write this number, and you can about this patent. Was tell you that to apply patent, people thinks that the product should be very complicated, and it should not be like that. Even a simple shoe can be applied for a patent. Even a simple paper clip, even a simple stapler, uh, that is these products are also have its patent. So it's a very simple product. If you create or if you invented a very simple product, that can also be uh, applied for patent. Uh, in the next slide, we will see that the LED stamps. Before that, in cricket, the wood stumps will be wood bale, and wood stump will be will be used in the cricket matches. At the time, the umpires are did not able to take the proper decision because of the wood bale. So a cricketer saw this problem, and he invented a LED bell. By inventing LED bell, he solved the problem. What is the LED bell? Simply, he introduced a LED light into the bell, and he applied a patent for that, and he has been awarded a patent. The number is WO 2011044642A1. You can go to the you can search it in the Google patent also, and you can read about uh, this patent in more details from there. So, for inventing a new product, first of all, what you have to search, you have to think what is the problem first. You have to identify what is the problem first, and what is the easiest and more economic way to solve the problem. You have to find. By this way, you can make a innovative product, and that product must be industrially acceptable. Means, suppose you make a product that is not industrial applicability is not there. So your product cannot be sold in the market. So you have to think that your product have to have the industrial applicability, must have the industrial applicability. So here the some famous inventions is there. You can see the nano car, hepatitis vaccine, Joypur food. Now you can say that at the time of introducing nano car, there was a Maruti Alto car was there, Wagoner car was there. So what's new in the nano car? Nothing new in the nano car, but Tata provides this nano car in a very economic way. So at the time, you can say that The Alto car is available at 3 lakhs, but at that time the same facilities are given by the Tata at 1 lakh. So it's have the economic significance. So what Tatas are done, the existing product, he improves the existing product in the economic way. That's why this car has been awarded patent. These are the some funny patents. You can see the small and very simple patents. A hat, baby hat, uh, that saves his eyes from the water. Mobile screen in the wrist, card reader, and the drone. These are all have patents, patented product. So now in the next we will see how now we suppose you learn that how patent can be created, how patented product can be created. Uh, Now after creating the patented product and drafting it, um, you have to file a patent in the patent office. So we will see how patent can be filed in with patent office. To filing a patent, you must be aware that you have to fill this five form first. You have to fill form one. In form one, you have to there are the applicant details will be there. The name of the applicant, who is the inventor, address of the applicant, address of the inventor, title of your product or your invention. This information should be right in the form one. You can simply download it from our website, that is ipindia.nic.in, or simply you can write in Google that form one for IP for patent in India. You can get it, or you can go to the ipindia.nic.in, and there is a section that forms and fees is there, on column is there, and from that you can download it and you can print it and fill it. Form 2, in the form 2, your details of the invention should be given. Title of your invention, background of your invention, particulars of your drawings, brief descriptions of your drawings, brief description of your invention, claims, abstracts, drawings. This should be right in the form 2. Under the form 2, your whole description uh, should be right under the form 2. And fees are not required for 30 pages and the 10 claim. If your draft will cross the 30 pages and the 10 claim, then you have to pay fees for per pages the per extra pages and the per extra claim. In the form 5, you have to declare the inventorship, who was the inventor of your invention. And in form 18, you have to form 18 is been filed for the request for the examination, and it shall be filed within the 18 months from the adverse priority date or the filing date. So we request everyone to that whenever you are thinking to file a patent, file all the form at once. Don't delay it, because sometimes people forgot to file form 18, and 18 months will be over at that time. 18 months will be over, and people not filing the form 18. So your patent will be revoked. So please at once. For the filing fee, for Form 1, for the natural person, startup, small entity, and for educational institute, the filing fee will be 1600, and for Form 18, it will be 400. So total fees will be 500. For Form 18, it will be 4000. So total fees will be 5600. And for other than the natural person, such that any company filing patents, so he have to file total 28,000 for a patent. So we request everyone to, before filing the patent, you please visit our website once and check there if if any fees updation is there, because he may be updated in 1 year, or time to time it is been updated before filing a patent. Kindly refer to our website and file the updated fees. Filing procedure: you can file offline, or you can file it on online. Uh, yeah. For filing online, you have to create a account in ipindiaonline.gov.in/epatent filing /go for login and do login. In this website, you have to create your account. It is very simple, as very simple. Simple means you have to give your name, email ID, phone number, and OTP will be there coming in number, and in this way you can log in. And after login, you will find there all the forms there, and you have to fill the forms, and you have to upload your inventions, the drafted inventions, and you have to submit it. And for that you have to buy some e-sign from the e-Mudra site. You can buy the digital signatures, and all the forms are signed by digitally signed by you through the digital signature. So in this way you can file the online application. And for offline application, you have to print out the forms from our website and fill it, and with your invention you can visit any of our offices. Our office is situated in Kolkata, Delhi, Chennai, and Mumbai, any of our offices, and you can submit with fees. You can pay in cash or in check or any other means. So how our online portal looks like? Our online portal looks like this, and simply you can go to the sign up option, and you can create your login account. Now, one another option is also there. Expedited examination. Expedited examination is newly introduced in our system. So for expedited examinations, what you have to do, you have to go through the Rule 20C of the Patent Acts or Patent Rules 2023. Who can file the expedited examination? Applicant uh, may file a request for expedited examination in Form 18A along with the fees as prescribed in the first schedule only by electronic transmission, duly authenticated within a period prescribed in the Rule 24B, or any of the following grounds. So who can file expedited examination? Any natural person can file, but the person must be a female. If a male want to file the expert examination, then he have to means jointly he have to file with a female person. Or any educational institution run or established by the central, provincial, or state act, or owned or controlled by the government, can file expert examination. Or applicant, a department of a government can file expedited. A startup can file expedited examination. A small entity can file expedited examination. For this case, for startup and small entity, you have to submit a proof that you are a startup. You have to submit a certificate, TPIIT certificate. Or for small entity also, you have to submit the certificate. For education institute also, you have to submit the proof that the institute is run by the government, or partially or fully run by the government or owned by the government. In this another case is another option is there. If applicant choose India as international search authority or elected as international preliminary examination authority in corresponding international application. In this way, you can also file uh, expired case. So these are the some option to file a expired case. And for expired case, what will be the fees? Fees will be 8,000 for filing a form 18A, and their filing fee will be 1,600. And for form 9, you have to file for form 9, and you have to pay a fee of uh, 2,500. So, what is the facility of the expired cases? The expired cases, the facility, the name itself indicates the process of this case will be fast. Means if you file a expired case today, you can expect the decision will be within 1 year. Within 1 year, either your patent will be granted or patent will be rejected. And if there is no delay from your end, suppose office send some objection, raised some objection against your patents, so you have to comply that objection within the time. If you are not delaying from your side, you can say you can get a decision within 1 year. So this is the case of expired examination. So now, after filing the patent, how your application will be processed in our office. We will see how your application is processed within our office. So after filing a application within 18 months, this is not the case of expired case. It is a case of normal case, ordinary case, normal case. If you come through the normal way, uh, this will take 18 months to publish your application in our public domain. After that, the if you have already filed Form 18, that is request for examination, your case is scrutinized by our department, that is REX, and decided whether your case belongs to mechanical or electrical or chemical, and your application is sent to the concerned examiner of that group. Suppose your case belongs to mechanical, it may come to me, and I will thoroughly examine your application, and I will search the prior arts of your application. Suppose through our search tool, through our search engine. Suppose I get a similar examination in the search by searching your application, and I will cite the that two or three cited document, and I may tell you that your invention is related to already there, and you have copied it from these documents, and you will, and we send a FER, that is first examination report, to you with the objection lists, and you have to comply that objection list within the 6 months. And if you fail to comply that objection within the 6 months, your patent will be revoked. And if you have to send a reply within the 6 months that how your invention is new and how your invention is different from the cited prior art. And any other formal objection will be also be there. Suppose there will be any grammatical error, that will also be there. Suppose you have paid a less amount of fees, that objection will also be there. Suppose you have forgot to submit any forms, or forgot to forgot to do any signature in any forms, so that will also be there. So you have to comply all the objections, and you have to send the reply within the 6 months. After that, it comes again to our examiner sections, and it will again examine that your reply will be again examined. Suppose and if examiner and controller uh, thinks that your reply is okay and a reply is in line, so your and if they thinks that it is okay, your patent will be granted. And if they thinks that it will be not okay, then again you have sent it we will send a ACR, that is second examination report to you, with the list of objections, again with the list of some other new objections. And this time we are offering a hearing to you. You can attend the hearing in online also or offline also, and you have to attend that hearing, and you have to the conversation between you and the controller and the examiner will be there, and you have to convince the examiner or controller uh, through your technical points, that how your invention is new. And if examiners and controllers are convinced by your words, your patent will be granted. And if again some objection is sustained, if some objection is again sustained, then your then your application will be rejected. So this process will take nearly 2 to 3 years, because after 18 months your application will be published, and after that it may take 2 to 3 years. So this time for ordinary application, this much time may be taken. And for expedited application, as soon as you file your application, and it will be published in our public domain, and it comes through to the examination section, and within 1 month you may get a FER, first examination report. And after within the 6 months, you have to reply the first examination report and comply all the objection. If all the objection is complied, then it can be uh, granted in the 6 month also. So if expedite process, it will take maximum, it will take 1 year to get a decision. So I've already discussed about the how examination is going on in our office, and the first examination report, how first examination report sent to you, and examination on the reply of the applicant, will you have to reply uh, according to the report sent to you. And after that you have to you have been offering a hearing, and after that the grant or refusal will be there. So this is the process, how patent application is processed through our office. Now I request you to if you have any questions regarding the patent application procedure or patent application process, you can question, you can ask me. Otherwise, I will move to the next section, that is design. If anyone have any queries regarding the patent, you can ask me. As you are working in a institute or a student of the institute, so you may have filed a patent, no problem, while filing patent, or while preparing for replying of a FER, that is first examination report. So you may ask me.
So, am I audible?
Yes, yes, sir. Yes, sir.
Yeah, Abhishek Babu, just some of faculty members we wish to know, they are under some process of some paper publication, journal publications.
Yes, yes.
So before communicating to just filing the patent, after filing the patent, can they publish their paper?
Yes, yes, yes. It is advisable from our side that whenever you have invented a new product or a new thing, please file a patent first. After that, you go for the publications for
So,
research.
which one is suggested actually after filing the patent?
Yeah, first file patent.
Okay, okay. Okay, thank you very much. Thank you.
Actually, what has happened, if you published the paper first, so it will come in the public domain already. So after that, if you file a patent, so examiner or controller can cite that paper also, that it is already in the market. How you can, how will allow you to get a patent for this product. There is a provision, if suppose you are the inventor or you are the owner of this product, so 6 month or 1 year time period will be there. If you publish a paper with within, and after publishing a paper within a 6 month or 1 year, you have filed a patent, that may be allowable. But I will suggest you to first file patent, then go for the.
Okay, thank you very much.
Okay. And any other question? Okay, so now I am moving to my next slide, that is design. Next topic, that is design. Design is a features of shape, configuration, pattern, ornament, or composition of lines or colors that applied to any article, whether in two-dimensional or in three-dimensional, or both, or in both forms, by any industrial process or means, whether manual, mechanical, chemical, separate, combined, which in the finished article appeal to and are judged by solely by the eye. So design is basically a artistic aspect of an article. It can be a shape of a product, or it can be a configuration of a product, or a pattern of a product. So how design, how we will judge that your design is new or not. Your design, it is solely judged by the eye. Simply, it is searched in Google or in Amazon or in means social sites are there already in the various social sites. And if we did not find the similar design product in the social sites, your design can be granted. And these are the some shape and configuration of some bottles are there. Every bottles can, the design of the every bottles can be registered. There are in this slide you can see that a design of a car, design of a inhaler, table lamp, and watch. So everything can be registered under the Design Act. A single item can be registered under the Design Act, and a set of item is also can be registered under the Design Act. Suppose a set of ornament or set of cups and sofas and shoes also can be registered under the Design Act. So these are the we have 4 offices for physical filing, for patent filing, and for design filing. We have 4 offices, that is IPO Kolkata, IPO Delhi, IPO Mumbai, and IPO Chennai. And as of now, IPO Kolkata is a main design office. So wherever you have you can file in these 4 offices, but ultimately your file comes to IPO Kolkata, and design examination is done in IPO Kolkata. So for the design fees, you have to pay 1,000 rupees for individual, small entity, and startup, and for 4,000 rupees for others, sized companies, big companies. You have to file. You have to pay 4,000 rupees. Here also you have to file Form 1. In Form 1, you have to mention the applicant name, nationality, legal status, address, priority data, prior registration data, signature date, etc. Set of representation illustrating various views of your article. Various view means the top view, bottom view, side view. You have to mention in your representation. If power, if you want to file a power of attorney, you can file it, and a signed document also you can file it. It is not a mandatory, but you can file. If you want to assign someone, you can mention it, and you have to file form 24. That if the applicant is small entity or startup, you have to you have to submit a proof for that. And specimen of the representation sheets, how your design application looks like. First, you have to your product will be there. Design of your product will be there in the top. After that, you have to write something of your product, how design of your product, and at the last, you have to sign it. Your design application is also be there. So our next topic is trademark. A trademark is any word, name, symbol, or a device, or any combination of thereof. It identifies and distinguishes the source of the goods or to others. Function and importance of the trademark: it provides exclusive monopoly over a class of goods or services. It allows the business entity or build a good public will or a brand reputation. It identifies the source or origins of the goods or the services. It assures customers about the quality of the goods and services. Here are some example of existing trademark is there. This is a trademark of McDonald's, Adidas, Nike, Google, Naukri.com. So trademark consists of collecting marks. It can be a certification marks. It can be a trademark tagline or slogans. It can be a shape. It can be a sound. Suppose in Pepsi the trademark is Dil Mage More. It's a sound. And suppose in Nike the right sign is the trademark for the Nike. And while applying for trademark, you have to search by yourself. You thought that trademark is already exist in the market or not, and already similar trademark is there on in the market or not. You have to search it after before filing the trademark application. Suppose you want to make a shoe company, and you want to keep your company name that is Adibas, BAS, and that is similar, very similar with Adidas. That is existing trademark is Adidas, and you want to make your company name Adibas. So that cannot be allowed. Your application will be rejected. So the properties of a good trademark will be inherent and acquired, and it must be honestly adopted. It will not be similar to the existing trademark. And before adopting a new mark, it is advisable to have search conducted and evaluated. It also avoid unnecessary litigation. Trademark is registered, then you can means emboss in your product that are uh, under the circle. And if your product is not registered, your trademark is not registered, then simply you have to write in it. The trademark registration is not mandatory. However, registration has a certain advantage. What advantage you will get? It it will means copying it will protect you, and others cannot copy your trademark if you register your trademark with trademark office. The registration available at national, regional, and international level. Initially, trademark is registered for the 10 years, and it can be further renewed indefinitely. And in case of non-use, non-renewable, and policing or no policing, the trademark rights may be lost. And existing trademark registration is governed by the Trademark Act 2017. Next is copyright. So criteria to work to be a copyright, uh, the copyright product must be originality, and it must have fixation, and it must have creativity. So various type of copyright will be there. That is that any literary work can be registered under the Copyright Act. Any dramatic work also can be registered under the Copyright Act. Any sound recording works can also be registered under the Copyright Act. Any artistic works, any musical works, any cinematographic works can also be registered under the Copyright Act. So copyright maybe have two types of copyrights are there. One is economic right and one is moral right. Economic and moral right is not non-transferable right. A moral right is remains within the original author. The scope of the economic right, scope is it may be a reproduction right, distribution right, right to create derivative works, right to communication to public, and right to public performance. Scope of moral right, right against distortion, and the right against rights of recognition are the scope of the moral right. So terms of protection, for cinematographic films, it will be 60 years from the date of publication. For broadcast reproductive rights, it will be 25 years. For performance right, it will be 50 years. Application process, you have to file a form 15, and Copyright Office UK. Again, in this case also, you can by person or offline, or you can file it on through e-filing facility also. Here some prescribed fees are there for literary and dramatic works, and artistic musical works. It will be 500. For artistic work, it will be 2000. For sound recording, it will be 2000. For cinematographic film, it will be 5000. Here some examination procedure is there. Copyright examination procedure is there. After filing a copyright examination application, copyright application, scrutiny will be there, and your formality check will be there, and your copyright examination will be there. If it will be no discrepancy, if examiner find no discrepancy, so it will be approved by the registered. And if there will be some discrepancies there, then a report, objection report, will be sent to you. And after that, if you satisfy all the objections, and your copyright application will be approved by the register. Otherwise, next topic is SICLD, that is Semiconductor Integrated Circuit Layout Design. This is applicable for the ICs related products that have semiconductor, that have chips, integrated circuit, that have integrated circuit product having integrated circuit, having chips, or having transistor, having any circuitry elements, can be registered under this act. So SICLD, the registration of SICLD is for period of 10 years from the date of application filing, or from the date of first commercial exploitation, whichever is earlier. These are various type of SICLD application, and the fees will be there. Respective fees will be there. You can refer it from here. So our next topic is geographical indications. Video, we will see how what is geographical indications. You can get a preliminary knowledge about the geographical indications. So please see this video.
चिमनी चोर के साथ घमासान के बाद अब आईपी नानी बिजी हो गई अपनी पोती की शादी की तैयारियों में। संगीत वाले दिन जब छोटू उनसे मिला तो
वाओ नानी, आप तो बिल्कुल छाए हुए हो। आपके सामने तो मधुबाला को भी कॉम्प्लेक्स हो जाए।
ओए, मस्का लगाना बंद कर। ये बता तुझे क्या चाहिए?
नानी, आपने तो मेरा दिल ही तोड़ दिया। क्या एक प्यारा सा लाडला सा बच्चा अपनी नानी को कॉम्प्लीमेंट भी नहीं दे सकता?
क्या तेरा कॉम्प्लीमेंट? अब बता तुझे क्या चाहिए?
मुझे कुछ नहीं चाहिए, बस आपके हाथ की वो स्पेशल वाली चाय पीनी है।
बस इतनी सी बात के लिए इतना बड़ा मस्का?
मस्का नहीं नानी, आप आज सचमुच बहुत ही रॉकिंग लग रही हो। ये साड़ी आप पर बहुत ही अच्छी लग रही है।
अरे ये तो स्पेशल लखनवी चिकनकारी है। लखनवी चिकनकारी पूरी दुनिया में मशहूर है। ये अपनी खूबसूरत और बारीक एम्ब्रॉयडरी के काम के लिए फेमस है। लेकिन पता है इसकी सबसे बड़ी खासियत क्या है?
क्या है?
ये एक रजिस्टर्ड जीआई है।
जीआई? वो क्या होता है नानी?
जीआई का मतलब होता है जियोग्राफिकल इंडिकेशंस, हिंदी में जिसे भौगोलिक उपदर्शन कहते हैं। ये किसी समुदाय का बौद्धिक अधिकार है, वो विरासत जिन्हें प्रोटेक्ट और एनकरेज करने की बहुत आवश्यकता है। मुख्यतः इन टाइप्स में रजिस्टर्ड होती है नेचुरल गुड्स, हैंडीक्राफ्ट्स, फूड स्टफ।
अच्छा,
चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं।
हाँ हाँ।
किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख। ये मधुबनी पेंटिंग है बिहार की, और ये है हिमाचल की कांगड़ा पेंटिंग। तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने का बहुत शौक है।
अच्छा,
ये कठपुतलियां देख रहा है?
हाँ।
ये राजस्थान की है। इसी तरह छत्तीसगढ़ से बस्तर ढोकरा, आंध्र प्रदेश से तिरुपति लड्डू, असम से मूगा सिल्क, नागालैंड से नागा मिर्च और मध्य प्रदेश के बाघ प्रिंट, ये सब रजिस्टर्ड जीआईज हैं।
ओके।
ये हमारे देश की कला और संस्कृति का प्रतीक है। हमारे देश में हुनर और कला का इतना भंडार है कि अभी से ही 300 से ज्यादा रजिस्टर्ड जीआईज हैं।
वाह नानी।
चल अब तू चाय बनाने में मेरी मदद कर। एक बर्तन में पानी ले और उबालने के लिए रख।
यस बॉस।
पता है छोटू, तुझे मेरे हाथ की चाय इतनी पसंद क्यों है?
क्यों है नानी?
क्योंकि ये स्पेशल दार्जिलिंग की चाय है। ये देश की सबसे पहली रजिस्टर्ड जीआई है, जो 2004 में रजिस्टर्ड हुई थी।
लेकिन नानी एक बात बताओ, इस जीआई से फायदा क्या होता है?
देखो छोटू, ज्यादातर जीआई गांव के समुदाय के होते हैं। इनसे कारीगरों, बुनकरों, किसानों की आमदनी बढ़ती है। उनको अपनी मेहनत का सही दाम मिलती है। साथ साथ खरीदने वालों को भी विश्वास हो जाता है कि वो एक जेन्युइन चीज खरीद रहे हैं।
ओह, वैसे नानी मुझे एक आइडिया आया है।
अरे वाह छोटू, तेरे को आइडिया?
यस नानी, अगले महीने फॉरेन से मेरे कुछ दोस्त आ रहे हैं। क्यों ना मैं उन्हें हमारे देश के कुछ सुंदर जीआई प्रोडक्ट्स गिफ्ट में दूं?
ये तो बहुत ही अच्छा आइडिया है छोटू। उन्हें ये चीजें जरूर पसंद आएंगी और हमारे देश की कला का नाम भी होगा।
देखा नानी, आपकी संगत में मैं कितना इंटेलिजेंट हो गया हूँ।
हाँ भाई, ये बात तो है।
और इस तरह एक बार फिर आईपी नानी ने आईपीआर का झंडा ऊंचा लहरा दिया।
So in this video, you will see what GI is, geographical indication is. In this slide, you can see some example of the GI. Uh, GI is an indication that identifies a product that has a specific geographical origin or a reputation that are due to that origin. So by its name itself, you can consider it that geographical indications is a product related to the geographical origin. Suppose Darjeeling tea, you cannot cultivate the Darjeeling tea in Bardhaman. So you have to cultivate the Darjeeling tea in Darjeeling only. So geographical indication, the product which have geographical indications are from a specific region, and it's the award GI loyalty is given to the community of that geographical origin only. It is not given to a particular person, so that the community of that particular area can do business from that product. So here some GI product, example of GI product are there, that is Darjeeling tea, Makhana Marble, Bastard Dhokla, Nilgiri tea. Here is Kanchipuram silk, Kathputia of Rajasthan, Bagh print of Madhya Pradesh. These all are already awarded GI. There are some fruits and also got awarded through GI. That is Maghai Pan, Alfonso mango, Cook orange, Kashmiri saffron, Sahai lychee is also there. So validity of patent is 20 years, design is 10 years, plus it is extendable up to 5 years. Trademark is indefinitely subjected to the renewal, and the GI is subjected to renewal. It is initially awarded for 10 years, and copyright plus 60 years. And who can apply for a IPR? Any person or the representative of him or her can apply, but for GI, an individual person cannot apply. You have to apply through a community of that particular geographical area. All IPs are designed in US Patent Office also to make a business in that country. So it is a territorial nature. It is valid only within the Indian territory. So points to remember: first protect, then publish. Before publishing your product in any national international journal, we request you to file a patent for that first. After that, you go for the publishing. It's at all IPRs are territorial in nature. It's limited to the boundary of our country or the sovereign authority. Registration is required in individual country. If you go overseas, then you have to register in the individual country wherever you want to go, and registration is done by the sovereign authority, that is Government of India. Rights are for limited period and no automatic relief. You have to file a infringement. annual fees will be there for the case of patent. Every year you have renewed it. Appointment of patent agent is not compulsory. Applicant can sign by himself, and he or she can file a patent. Now, what are the career opportunities in this field? Yeah, government job, you can become an examiner of patent and design, examiner of trademark and GI, examiner of copyright. And in the private field, you can become a patent agent, trademark agent, JRF or SRF in a patent facilitation center, and private litigation, patent litigation, and other opportunities in the private sector is also there. So, if you want to do further training or any customized training on patent, trademark, on any IPR, you can contact Rajiv Gandhi National Institute of Intellectual Property Management, that is RGNIIPM, that's situated in Nagpur. And email ID is also there. You can contact them, or you can arrange for a any customized patent related program or IPR related program. Or if you have any queries, you can send them in mail, or you can even send a mail in Kolkata@gov.in, or you can send a mail to me also. And right now, if you have any queries, you can ask me. My end of my slide, and we will conclude our program. So I request everyone, if you please unmute yourself, and if you have any queries, Jando.
Yes, sir. So, anybody have any question?
I think there will. I think there any questions.
Okay, I think the nobody have any question. So, thank you, sir, for your this motivational and the informative speech on the patent filing, trademark, all these things. So, I would now request to our Dean R&D, Professor Dr. Ashok Kumar Shah, to give the vote of thanks. Sir, are you there?
Am I audible, Janto, sir?
Yes, sir, you are.
Yeah, I'm
Yeah.
Okay. So, good afternoon, everybody. On behalf of Budge Institute of Technology, BBIT Kolkata, I would like to convey my sincere vote of thanks to today's guest speaker, Mr. Abhishek Sen, Examiner of Patents and Design, Group A, Gazetted, the Patent Office, Kolkata, Ministry of Commerce and Industry, Government of India. I would also like to thank the management of the college, Chairman Sir, Vice Chairman Sir, ED Madam, and Dean of Academics, Dean of Student Affairs, Registrar, and Dean of MBA, and all other HODs and faculty members for their support to organize this webinar. I would like to thank the IIC cell of BBIT Kolkata for organizing this webinar, and I would like to give the special thanks to the convener of the IIC cell, Professor Jayanto Bosak. I would also like to thank Dean of Students, Siladitya sir, for sparing and staying here in the webinar for till the last. I would also like to thank my respected faculty members, staffs, and dear students for attending the webinar. Once again, I would like to thank the IPO office Kolkata and Mr. Kausik, Dr. Kausik Bag also for extending his support whenever we require for organizing IPR and its management related webinar and seminar whenever we require. So thank you very much, sir, for your support. Thank you very much. Over to you, Jayanto, sir.
Thank you, sir, for your vote of thanks. So once again, we thank you to the Mr. Abhishek Sen for your this speech. Okay, so I think we can end our session now.
Okay, sir. Thank you, sir. Thank you, Jayanto sir and Dr. Ashok sir and Professor
Yes.
Narendranath Jana sir. Hope we will meet again and we will again
Sure.
continue our discussion on IPR.
Surely, Abhishek Babu.
Okay, sir. And if you have any queries, further queries, if you think you while filing patent or while drafting patent, you can call me or Kaushik Bag, Dr. Kaushik Bag. Both of our number is with you, and email IDs are also with you. So you can directly contact to us. We will help according to our capacity. And I hope you will file a patent, trademark, and patent, trademark, and other IPRs in the coming future. We will see from Budge Institutes. Thank you, sir. Now I am concluding.
Abhishek sir, we are under process of filing one patent. So again, we will be approaching you very soon.
Okay,
Thank
okay.
you very much. Thank you, sir. Thank you.